I need a refresher.
He's still talking. He doesn't realize we're actually on. But, you know, whatever. That's the way it goes. So we have competing jokes to start off with. And I have to give credit to JR for being responsible for this joke because he threw it out and I took my way and he took his way. So why don't you go first?
I don't even remember what the joke was. We didn't really have a joke. It was a witty, snide comment about P. Diddy.
So what was your comment?
I asked him. My comment.
Oh, before you start, right? We want to get feedback. Which one you prefer?
Okay,
which interpretation do you prefer?
So we're going to use this as our naming convention for whenever we talk about P. Diddy moving forward on the stream. So I had asked Richard if we were going to talk about P. Diddy, and he had made a comment about what we should be calling him. And Richard, what was your suggestion we call P. Diddy when we refer to him from here on out?
Yeah, I heard somebody rumor, whatever, opinion, not truth. He suggested P. Diddle.
P. Diddle. Yeah. And I said we should call him Prisoner 69.
Yeah, which I like too. But
so chat, let us know in the comments which you would prefer. Is it P. Diddle or Prisoner 69? Yeah. So let's just get this out of the way first because I'm seeing some comments here. So bankruptcy is in the title because Metamaterials filed for bankruptcy weeks ago. And I was on a space last week.
Before you get there, hold on a second. So this is just entertainment, it's not legal advice, of course not. It's just opinion, whatever, blah, 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 blah. Don't rely upon it, make your own decisions, etc. Now go ahead.
Right. And so we thought it would be a good idea to kind of just talk generally about the bankruptcy process because some of the questions we got were pretty straightforward questions, but we just figured we'd at least chat a little bit about what bankruptcy is, what it does, what the purpose is, and answer some general questions that we might get on the street. That's all. GTI is not filing bankruptcy. Nextbridge Hydrocarbons hasn't filed bankruptcy. So please, everyone, take a deep breath. That's where we're at.
Yeah. It has nothing to do. This was like some topic that this guy on the other side, so he's on my left, this guy, he wanted to talk about it. That's the reason why I put it up here. It has nothing to do with anything else.
Somebody just made a comment. Pete Rose is dead.
Did Pete Rose died today. He was 83.
Oh, did he? 83.
Yeah. Also, Dikembe, I should have mentioned this. Dikembe Mutombo died today at age 58.
Who's that?
Dikembe Mutombo.
Oh, is he that? Was he the basketball player? Yeah. I saw it. Yeah, I didn't know Pete Rose passed away.
Yeah, it's a tough day in sports. For those of you who don't know, Pete Rose, he was a famous baseball player for the Cincinnati Reds. I think he played with the Reds.
Played with the Phillies too.
Yeah, end of his career with the Phillies, but he was like an all-time great. So sorry to see him go. He was kind of a dick, unfortunately, and he bet apparently on baseball. And because of that, he never got into the Hall of Fame, even though he had qualifications to do it. So it's kind of a sad story. And what he would do is, and he died in Las Vegas, is his whole life after, probably the last 20 years, was he'd do sign autographs at some store in the mall at Caesar's Palace. So kind of, a sad way of going out. Dikembe Mutombo, on the other hand, was a kind of a ambassador, a very likable guy. But he was 7 foot tall, and often basketball players of that height or individuals of that height often have heart issues and have short lives. Unfortunately, he didn't die of a heart issue. Apparently, he had brain cancer. So that might be a Northwest bio, right? Northwest bio was for glioblastoma, I think. That's the most common form, I think, of brain cancer that most people die of in the world. But unfortunately, he was only 58, young guy. Really, for a guy who's much older than that, that's a young guy. Even for JR, who is way older. I mean, way older than that. It's a kind of a shock.
58, hell, that was 30 years ago.
That's right. That's 35 years ago, I believe. So we will talk a little bit about the bankruptcy. We're going to talk about GTII. We're going to talk about my favorite terrorist group, Hezbollah, tonight. We're going to talk about a bunch of stuff about GTI in terms of like process and where it's going, and anything else that you guys want to talk about. We will do that also. So it's kind of like a contrasting selection of topics, and I don't know how this is going to go. I don't know how long I'm going to do this, but I told JR this. We'll see. Starting tomorrow, I think 3:30 Eastern, I'm going to do like a 30. I'm going to call it like a newscast. It's not going to be exactly a newscast, but I'm going to go over the news of the day. 30 minutes every day. Obviously, it's opinion because it's, what's not opinion. But I'll try to kind of summarize things that kind of interest me in the news. And I've been kind of a news hound all my life. So hopefully it'll be of interest. If nobody comes, then so be it. But I'll talk to myself because I like talking to myself a lot. I do that a lot.
You're going to live stream it?
Yeah. I'm going to live stream it.
Where are you getting your news items from? I'm just curious.
I'm just going to kind of look at a bunch of general sources and kind of put together kind of what's going on that day. It'll be like the day of. So whatever is going on that day that interests me, I might kind of discuss. And I've always been interested in news. Not everybody is. So maybe it'll make it convenient for people to get some summary of news that they might find of interest every day. And also I try to do it as I'm trying to play devil's advocate pretty much most of the time, which is one thing that lawyers get trained at doing. So even if you're representing a scumbag, you somehow figure out a way of saying, he's a darling. So that's the same thing. So I can kind of do both sides. So hopefully I'll kind of present a more narrow view and whatever. I'm putting JR to sleep, obviously. So before we start, okay, it's his knee. So what's your problem? Bring us up to date about your stupid knee.
Wow. I had knee surgery and it's swelled up. It's got fluid in it. It's like the size of my thigh.
Okay.
Keeps me up at night.
Okay. Well, are you keeping it? What are you supposed to do? Let's see. This is for general use. So if you have like some part of your body that's swollen, you're supposed to elevate it, right?
You take an anti-inflammatory, you elevate it, and you ice it.
Ice it, yeah, but you can't ice it too long. You can do like 20 minutes max.
Because they don't call it ice anymore. It's called cryotherapy.
Okay, because it makes you cryo.
Just put a fucking ice pack on your body part.
It makes you cryo. It makes you cryo if it's on too long. Yeah, so like the physiological effect. Now, let's talk about physiological effects. The physiological effect is if you keep on ice too long, it actually makes it swell. Right. So that's why you can't keep it on too long. I know.
15 minutes, and you shouldn't put it directly on the skin. So
yeah, you should put it indirectly on the skin. So you should put it on your, like, if you have a friend, put it on your friend's skin. That's kind of like whatever.
I'm not a doctor, but I did stay at a Holiday Inn last night. So.
Well, I hope you recover, because I really, the Olympics are in LA, I think in 2028. So I expect to see you in the senior or the senior Olympics.
22 J-Dog. Yes, it's a torn meniscus that they repaired. They didn't clip it, and they trimmed some of the bone too to make it fit correctly. They were supposed to do a root repair, which they were going to drill into my leg, but they didn't have to do that. So this just meniscus tear.
And again,
man, it hurts.
Again, like I said, that's the price you pay for playing professional football. Whatever. That's the way it goes.
I was a walk-on.
That's the way it goes. I haven't even done the jokes yet, and there's a 26-minute joke. You remember there was a 26-minute joke?
Go.
Last week? The 26-minute joke today is sponsored by Big JR. He's not even here, and he doesn't even know he sponsored it, but he's sponsoring it tonight. So I don't know if you heard, but that guy from Hezbollah, the leader, he got kind of, it was didn't go too well for him. So right before impact, what did he say?
I don't know.
Holy Shiite.
That was not good. Not good.
Thank you.
Not good.
All right. Politics. Do you know where the word came from?
No.
It's two parts. Poly being many, and ticks being bloodsuckers. So many bloodsuckers. That's the origin of the.
Did you make that one up yourself?
Do you want me to?
No.
Okay.
These are subpar tonight, but
Thank
continue.
you. Thank you. No, I think it's your knee. I think it's your knee condition. I blame your knee condition. I'm going to hold one back for the 26-minute joke because it's really good.
26-minute joke. You got it.
So before we before we go into like the economics, because I'd like to talk about world events. So obviously, other than JR, because JR, by the way, so I asked him this question. He has no idea what's going on anywhere. He's just focused on his knee. That's what he's well
It's on the
versed in.
sofa, man. Come on, cut me some slack.
That's it. But obviously, there's been stuff going on in Lebanon, and I find it, so the person who was killed was Nasrallah, was the head of Hezbollah. He's been the head of Hezbollah for, I think, like 32 years, which is pretty amazing that he was able to kind of evade any kind of strike against him and all that time. It may have been calculated, may have been like that they never intended to because they were concerned about what the potential blowback might be and times might be different. But so he was struck in a neighborhood, I guess, outside of Beirut and killed by a strike the last couple days. But what was pretty amazing about that is it was like some huge, some innocents obviously got killed, and that's a difficult question for me because I have this thought. Back, if I were living during the time of Hitler and I had to kill civilians to kill him, would I do that? And I probably would. That would be my choice. And then on the flip side is, I remember Clinton had an opportunity to kill Osama bin Laden. They had an opportunity to make a strike, and I don't remember where it was. It was some country. He was there with some civilians and I think a Saudi Arabian ambassador or something. They identified him, but they elected not to go forward with the strike. So as a result of not going you could argue that as a result of not going forward with the strike, we ended up with 9/11. So if I were going to evaluate, should I have killed the civilians there? I would have said yes. And so, because my view, whether war, obviously, who likes war? There's, other than maybe defense contractors might like war, I guess. But otherwise, probably not very many people are really war advocates. But what I would look for is what terminates things the fastest and would kill the fewest people, because it's going to happen. There's nothing I can do to stop it, but if you can speed it up so less people get impacted, then I think that's positive. So even though, like, when I say I'm for targeted assassination, I am for targeted assassination. If you could take out somebody as opposed to taking out a bunch of people, I think that's the morally correct thing to do. People, for whatever reason, I haven't quite figured it out. It's the concept of intentionally killing somebody that bothers people, as opposed to saving other people, much more than that assassination. So I don't understand. I'm pretty much a pragmatist about everything. So even about war, I'm a pragmatist. I want things to be done as quickly as possible so the least amount of people get impacted. It all sucks. It's not like it doesn't suck. It all sucks. But the guy Nasrallah, we have to remember this particular guy. And again, I raised this issue last week about somebody else. Nasrallah is the kingfish here. He was involved in the bombings that killed 283 servicemen, American servicemen in Beirut. Multiple other bombings. But beyond that, they were involved and assisted Bashar al-Assad, who's the head of Syria. If we all remember, do you all remember what happened in Aleppo? Remember hearing about that, the destruction and the deaths that happened to the Syrian citizen when the government of Syria went after them in Aleppo? They completely destroyed. Basically, you would equate it to the way Gaza looks like today.
Yeah.
But it was the government, and who assisted that government to make sure that was accomplished? That was Hezbollah. That's why they're despised by most of the Syrians. And you have to remember, even Lebanon is a fractured country. So part of it is Sunni, part of it is Christian, and part of it is Shiite. By the way, that's where the source of that joke came from. And the Hezbollah is Shiite. So after he was killed, if you saw the Arab world, it was a mixed reaction. There were a lot of parts of the Arab world were very happy about it because they don't align with them with that. Some were not, kind of a mixed bag. I'm sure everybody doesn't like their territory interfered with, but I'm glad he's dead. So, that's just my opinion. I hope that it creates fear for all terrorists that they are potential targets. And, we hear a lot of talk. We hear a lot of talk about everything, like MMTLP. We hear a lot of talk, but not a lot of action. So
Right.
if I was a Hezbollah guy today, and I was going to be taking over a position of command, it would certainly cross my mind how long my command position was going to be there. So anyway, those are my 2 cents about what's going on. I'm always sad for the civilians who get impacted, but I'm also thinking about that particular scene, an apartment building, because I follow this pretty carefully, obviously. So it's an apartment, a bunch of apartment buildings in a fairly densely populated area. There was a big headquarters 60 feet below ground. So I was thinking, so how do you do that? Do you build like the headquarters, you cover it up, and then a contractor comes up and builds the apartment buildings, or it's the same contractor who builds the headquarters? They put a fence around it, they do their thing, and then they build it, and the same contractor builds it for secrecy purposes. But I gotta believe, this is my feeling, that if I lived this, and maybe I'm wrong, but if I lived in an area and beneath me there was a headquarters, I would suspect that somebody in that complex would know, and that information would be passed. Just because somebody who's building the building might have a friend that lives in an apartment building and might want to pass along to the friend, you might want to not be there. Were you going to say something?
I'm sure someone always knows. Someone always knows. I'm just paying attention to the comments. That's all.
Okay. Anyway, I'm gonna. That's enough of a speech of that for today's purposes. As we were coming in, I think it was confirmed that the Israelis had started a ground incursion into Lebanon. I think it was announced about 20 minutes ago. Their goal is at least the stated goal is to push them back to the Litani River, which is about 18 miles from the border. And apparently in 2006, I may be wrong with the dates, in 2006, when they settled a prior war involving Lebanon and Israel, there was a UN resolution that was passed, 1701, and the agreement was Hezbollah would be disarmed. They would move back behind the Litani River, which is 18 to 20 miles from the border. I think the reason why that's significant is that's a significant distance in terms of shooting missiles. And also, I think it takes it out of line of sight. So you can't see where you're shooting. And I would guess that's probably a problem with targeting. If you can't see what you're shooting at, I would think. But I don't know. But so there is a prior UN resolution that has not been complied with. That's why we're here today. That's where they got to today. So let's talk about, so that's that part. So let's talk about BK.
Why don't we talk about GTII first? Because there's a tremendous amount of comments coming in about what's going on.
Okay, GTII 1, it's going to take a while. So even though if I give you information all the time, that doesn't translate that's going to speed up the conclusion. That just means I'm giving you information. That's all. So it would be unreasonable to expect things to get done in, days or weeks. It's just not. It's going to take longer to do, and that's just realistic. I know, though, this I know for certain. I know that the receiver has been active and moving forward and contacting everybody that needs to be contacted. I know the counsel for the receiver I've spoken with also is very competent and professional and on top of it. And they're moving forward with the intention, of course, completing the audits, getting that all corrected, getting the company uplifted and uplisted, so it's tradable and moving from there. Obviously getting control of money and all that other stuff. But the first two things that they're working on is getting everything corrected that needs to be corrected. Because if that doesn't get taken care of, then everything else is BS.
So let's take a step back.
Mhm.
So now that the receiver is in place, is it fair to say that the company is now being run again? So things that should have been happening are now happening.
Yeah. Yes. But this is a company that's not like producing a lot of anything. But yes, the receiver is, to the extent the company is operating, is operating it.
Right.
The idea, of course, is down the road because this is, again, it doesn't make sense unless we get to this point, right? I mean, it's great. So we've made a ton of progress getting it to this point in time. But unless we get it to the finish line, then not so great. So at this point in time, we have to clean up the mess. Once the mess is cleaned up, then they can go forward and do whatever. I mean, I saw somebody talking about this, about if an acquisition or something like that. I would be surprised, and it wouldn't be me to make that recommendation, but I'd be surprised if anybody would be involved in the acquisition until they saw the company cleaned up.
Yeah.
I would, if I was counsel for that company, that's what I would say. So
right, because they're going to do due diligence and they're going to want to see all the financials and all that stuff, and they just don't.
Yeah, and obviously, based upon what we know to this point in time, it's kind of a messy situation. So, besides everything else, they're probably going to want to understand, various issues, and that takes time. And I don't see anybody who wasn't absolutely familiar with what's going on now. I mean, if you were like an insider and you knew everything, okay. But anybody who's not, to get to the position where you were comfortable doing a real deal, I would think it takes some time, and they'd have to be clean. I don't know if that answered that question. So, so the receiver, I can go on from there. So the receiver is moving forward in terms of the litigation where we are right now, just to bring everybody up to speed. So there's 2 lawsuits pending. There's the lawsuit, and I'll focus on the ones in Nevada because that's where the most of yous are more interested. That one in Nevada, the receiver was appointed, obviously, and it took over. The bad guys, in my opinion, filed a motion for reconsideration and a motion for stay. That's going to be heard sometime, I think, in late October. So I don't know what really that's going to mean, like 2 months into the receivership, but whatever. But at the same time, they filed a motion to withdraw, the attorneys. So the attorneys in Nevada filed a motion to withdraw as to the individual defendants and GTII, but not as to David Reichman. David Reichman substituted a new counsel in Nevada. So he's got new counsel. The other defendants, as of now, no new counsel, and GTI, no new counsel as of now. That could change. It might be a conflict issue also, but that could change. But as of now, that's the status, which is interesting. It creates obviously an interesting scenario. I don't know if somebody's going to come in and represent the other individual defendants. GTI, in essence, is the plaintiff in that because it's derivative action. But it's an interesting scenario. We'll see how it works out. The motion to withdraw said that there were basically irreconcilable differences between the law firm and the clients. And it was beyond just the pay. This was kind of curious. I don't know what it is. And this is my opinion, whatever. But in a motion to withdraw, you're supposed to not like put your client out, hang your client out to dry. So let's say your client's a complete scumbag, hasn't paid you, hasn't returned your call, whatever. You're not very fond of them, let's say by that point in time, because you spent a bunch of time and haven't gotten paid. You're not supposed to tell the court and the other side, my client's a scumbag, not trustworthy, like that. You can't do that.
You're not allowed to do that?
No, you're not. Now,
Bullshit.
I think used to. I think they used to let you do a lot more of that. Now, if I win a case and whatever happens and I want to get out of the case, you actually, and the client is not being responsive, you have to file a motion, and in the motion you kind of have to basically say that you have irreconcilable differences, without kind of getting into your client's a scumbag and hasn't paid your bill and they don't return the call. You can't do that part, but you just kind of have to lay it out very narrowly, and the judges are very considerate in terms of letting you out also. So if you file a motion, unless it's
Oh yeah, they have to be.
Yeah, unless the judge is, whatever, doesn't like you, or else it's like a complete mess, you can get out. So, but it's interesting because they kind of suggested, and I have other reason to believe this. So it's not just me looking at the papers, but something other than not getting paid. I do believe, by the way, that is one. So one element of their wanting to withdraw is not getting paid. That's typical. I don't know that for a fact, but if I guessed that as a reason, I'd probably be right most of the time. But I've been told that there's another basis, and I don't know what that other basis is. We know there's we know about the I'll get into that too, because it's kind of interesting. The conflict of interest, we know about that. Right. But I was wondering, what other reasons would you want to get out, but you couldn't talk about, and you'd have to. So do you remember, you're back there, what kind of things would make you have to leave a case?
Thinking.
Yeah.
Well, you have a conflict of interest.
Right.
They're not paying their bills.
Right.
Which is a valid reason.
Right.
Gosh,
what happens like your client says, go steal the files of the other side?
Well, is that engaging in illegal, knowing your client's engaging in illegal activity?
No, if your client tells you to engage in an illegal act. I'm saying if your client says do something that's illegal or unethical, or
unethical.
Or if your client obviously says, it acknowledges criminal misconduct,
right? Then
you're kind of stuck. You have to
but that's not a reason. Acknowledging criminal misconduct isn't a reason to withdraw, is it?
Yeah, if I came to you, let's say the facts.
Is that a reason under the
I'm going to give you a fact situation. So let's say that your client comes. Yeah, as long as you don't know, I think you're fine. You're okay, because you can't call your client as a witness at that point in time either, because you can't suborn perjury. So I'll explain that. So the issue would be, So the client comes to you and says, well, I just robbed the bank. You can't call your client as a witness now, because if you call them as a witness, they would, and they testified to what the truth was, you'd have been suborning perjury, which is a felony, and it's a big no-no. So your basic position there is you got to withdraw, because you really can't represent the client at that point in time, the best interest of the client. So maybe if the client says they're going to commit a criminal act, because as that famous case involving the psychologist, do you remember that case, Tarasov? This is like 400 years ago when I graduated law school. I graduated law school before there was even law schools, if that's possible. There was a case involving a psychologist working for UCLA, maybe?
Took notes on a stone tablet.
We didn't have even the stone tablets. It was before the stone tablets. There was a psychologist working for UCLA. His client came and said he was going to kill somebody, and he didn't inform the cops. And after that, and the person got killed. And after that, they imposed a duty upon that under certain circumstances to inform about it, that this psychologist had it, even though there was privilege, because there's a privilege, right? If you go to a psychologist, what you say is privilege, but it's not absolute. Whereas if you go to an attorney, what you say is absolute unless it's, you're planning a criminal enterprise or very narrow, but it's got absolute protection. So it's different. You can have like protections, but not of the same quality. I don't know how that relates to anything.
But is my recollection of that sort of subset of rules is if a client confesses to an attorney, or the attorney, the way I was remember it is if the attorney's corporate counsel, excuse me, if the attorney's working in a corporate counsel capacity and becomes aware of illegal activity, there were 2 or 3 different options the attorney could engage in. They could resign under protest, but they had to be quietly. They could report the illegal activity to the authorities, but they would still be subject to the rules of professional responsibility and could be disbarred because of the attorney-client privilege. Or they could take it up the chain as far as they could and report it to, whoever the CEO was. But given what type of illegal activity they were finding out about, there was a good chance the CEO was involved, because at that level, you're engaged with senior leadership when you're in a corporate counsel capacity. That was my recollection.
Okay. Well, what's interesting about that, and I don't know, I'm just like, we're just talking, but one of the attorneys who reached out in GTII on behalf of one party, this particular attorney, his background was white collar criminal defense, which I don't think that was by just coincidence. That says that somebody has some concern about that. And that's fairly recent, so I was struck by that.
Well, they should have some concern based on the judge lambasting.
So, by the way, that's why I asked you that question about why you might withdraw, right?
Right.
And that also makes me wonder. And I've talked about this. I didn't, and I thought, I'm just speaking out loud because I don't really know what went on, other than I see what's in the pleadings and what I suspect, whatever. But if somebody thinks they have criminal exposure, if I were their counsel, I wouldn't let them answer a word. I would, if we were like in a for example, because I've been in that situation where the client was also charged. I think I've mentioned this on one of our great videos here. The client was a CPA. He was hired as an expert. He was in a big divorce proceeding. I mean, it involved many, many, many millions of dollars. He made some determination about who was supposed to get what or whatever. Very significant. While he was on the stand, he lied about what school he went to. Like let's say again, he went to Pierce Junior College, but he said he went to Harvard Business School. Let's say it's that kind of disparity. In the decision by the judge, he expressly stated that he relied upon the opinion of that expert in coming to the conclusion. After the fact, the expert was charged with perjury for lying, and may have been other claims beyond just perjury. We were representing him on the civil side because where I was working, we did defense of like accountant's malpractice, which can you imagine how exciting that is? Accountant's malpractice. Yeah, it's about as exciting as it sounds.
Whew.
Yeah. Anyway,
watch fucking paint dry.
He's being deposed, and he had criminal counsel with him at the civil deposition. So it's separate proceedings, but he's got a criminal lawyer with him. Didn't answer a question. They asked him his name. Did he say his name? I don't even know if he said his name. Yeah, the reason why you can't do that is because it's like some silly rule when you take the fifth. Rule, and I'm not a criminal attorney. Again, another thing I'm no criminal attorney. But the rule is something like if you give an answer that opens the door for another answer, then you may have waived the privilege, and then they might be able to force you to testify. So if you give your name, arguably, that might open the door. So some people might not even give their name and go from there. So again, interesting to me that the law firm suggested they were getting out of the case for reasons beyond just the economic reasons. And it was interesting to me that an attorney whose specialty was white collar defense was involved. Those kind of things kind of just, it struck me as interesting.
Right.
Getting back to, and again, if any other questions that you see, just kind of jump in. But before you go on, so kind of to bring you up in terms of timeline, because it's always helpful. Next hearing, I believe, is in Nevada, is October 14th. That's the motion for reconsideration. So that's the other side claiming that the court should not have granted the receivership motion, or if they did, they should have let Mr. Rabari be the receiver. That's their position. I don't really think it's a well taken motion, especially with the way the judge came down. Now you have in your possession a copy of the order. And now that the judge has come down he came down pretty harshly on them. So very unlikely, but that's a next date. And theoretically, things could change. But each time if they don't prevail, each time that happens, the more they kind of unfortunately, down the tubes. And
Let's get the roles straight here. I'm the question facilitator, not the answer.
all right. And the other thing is interesting to see is what happens if nobody defends those other defendants. Who's going to pay for those legal fees?
Yeah.
I mean, I don't know. So anyway, this month there'll be a bunch of legal proceedings. I don't know, how they'll turn out. But after this, once all these hearings are concluded in Nevada, so once we get to a point that whatever attempts at circumventing or undoing the decision to this point in time happens, at that point in time, it kind of shifts then to the receiver. So legal action then kind of goes to the receiver's side. So to the extent that he needs to pursue someone or pursue assets, it would be he and his counsel that would be doing it. Our counsel, as I would call it, we would do whatever is necessary, but really we'd be secondary to the receiver counsel at that point in time until it need be. For example, if they were not providing the assets, let's say the order says you got to turn over all the assets, bank accounts, whatever, and they didn't, let's say they weren't doing that, and let's say they refused, then most likely it's probably the receiver's counsel that would be handling that legal proceeding as opposed to our counsel. Kind of two separate actions. And again, notwithstanding the receiver, we have an action that's ongoing for damages, etc. And part of the receiver's task in that order is to secure assets, get them back. And again, the way it's structured, he only gets paid if he brings back assets. He doesn't get paid otherwise. So we're kind of we're on the same team. If he doesn't bring anything back, he's just wasting his time. So I feel that's a good setup. Were you going to ask a question, sir?
No, I was just going to, I wasn't sure when you were finishing. Someone did ask about what's going on with, what's the latest with your defamation cases.
Oh, okay. So my defamation
Yeah,
cases, so the law firm has filed a motion to withdraw for all three parties. That's going to be heard October 31st. I would guess it's going to be granted. We are going to extend the hearings on the dates of the motions that are pending till probably November 21st. And they'll have some short period of time if somebody comes in to represent the individuals, which I don't know because the attorneys don't know at this point in time. I would think it's probably less likely in my case than in the other case, but I don't know for a fact. So I would say probably sometime next month I'll know more about it. Sometime late October. I have my request to dismiss and whatever. I spoke to the attorney. Oh, that's interesting. So I spoke to the attorney today who represents the bad guys who are the plaintiffs, and we talked a little bit about the conflict. I thought it was an entertaining discussion. So here's the conflict again. And this is again, this is like stuff that lawyers learn in law school, probably like first year. I think it's first year law school. And, you know, lawyers are not supposed to engage in situations that demonstrate an appearance of impropriety. So it doesn't actually have to be like you did something wrong. It just has to look. It has to look wrong. And that's kind of the standard. So, and that's kind of like a base standard. Obviously, there's a lot of rules beyond that. So, but one of the rules is you can't represent a company and its directors unless you get a conflict waiver between the two. So the company and the individuals would have to say, we've been fully informed, we understand there's no, you know, despite what you've told us, we agree that we let you handle it for all three. But there literally can't be a conflict. It can't be like an actual conflict where one side in this particular setting, GTII, suffers at the hands of the other, because that would be not a fair situation. So you would argue that you can't waive that conflict. And then if you're representing all three parties and you can't waive the conflict because it would hurt one of them, then that's a conflict of interest. But we don't stop there. This is where it gets bigger. And I don't think, again, it's funny because he said they have an expert. This is what he told me. He was playing up his credentials and his skill set, whatever. And then he told me that they run this by some ethics expert before they file. So, okay. So I think about that. And again, I just told you about that conflict that it's on my case, just on that case. But we have, at the same time, we have the other case, which is GTII on behalf of GTII as a derivative action. Me and whoever else, 200 people, are suing some of those same people represented by the same law firm. So in that case, they're opposed to GTII. They're opposing a derivative action that would benefit GTII. In the other case, at the same time, they're operating on behalf of GTII. There is no way that is not an impossible conflict of interest, because on one side, you are acting to the detriment of your client. One way or the other,
Absolutely, you are.
GTI
Absolutely.
on one side, you're making it harder to recover or something. That's not a possible solution. So when the guy tells me that, this is my reaction. Maybe he did. Maybe he did. So like when I have conversations with other attorneys, if they're, I generally find the ones that aren't blustery are less full of crap, in my opinion. So like if somebody's trying to play up their status, that's usually, I think, less of that person,
Right.
generally in that situation. So in my mind, this is so obviously a indisputable conflict of interest that one of the reasons why these guys have to get out, they've even cited in their motion. So they filed a motion in my case too, to get out. And in it, one of the things they talk about is the granting of the relief in the receivership case. And I found it interesting. That's the final order, not when they found out. Theoretically, when the minute order came out, this would be my view of it. So you have to act reasonably. And again, it's the appearance of impropriety, not impropriety. Right. So when the judge issues a minute order and it says, you know, there's basically, it's saying your guys acted inappropriately, which created a conflict, obviously a conflict of interest at that point in time, when the individuals have been found to be engaged in misconduct. That obviously is a conflict between the individuals and GTII. When that happens, that's when they should have bailed, not when the final order came out. The court had already, because there was an appearance of impropriety already, which obviously finalized in the final order. But But I believe, again, when somebody says that, it makes me believe that they understand they got a problem. Not that, because they're just trying to bluster, intimidate, whatever. I will still do, in my case, kind of an answer, I'll do what's best for me in terms of getting out of here and not wasting time, because I've wasted a lot of time, obviously. And at the same time, I've assisted and am assisting the other case. And that's really what listen, if I wasn't in this case, I wouldn't be spending my time on this. I'd spend all my time helping on the Nevada case. So this is more just a distraction, whatever. And again, I think it was purely done to shut me up. And, maybe it did for a while. I don't think in the end.
It did?
Well, I don't think in the end it really has worked out great for the client.
No.
Yeah. So, and again, I don't know if that's the client or that's the attorney or a combination, because you got to, to those of you out there, sometimes the client is going to do whatever they want, and you could tell them, whatever, and they're going to ignore you. They're going to do their thing. A lot of times the clients know better than you. Sometimes they may, but oftentimes they don't. And, in the legal parlance, they probably don't. But, clients come of all shapes and forms. So we have the two actions. So in October, November, we'll find out more about my case. October, November, we'll find out more about that case. In the meantime, I think because I saw it referenced, and I knew about this also, is somebody posted on X that they had reached out to Paul Strickland, the receiver. And he had responded really quickly, and they were impressed by how quickly he responded. And he had referenced that he's going to give out some kind of interim statement to shareholders at some point in time. I think I'd referenced that also, but he confirmed that, right. And they were impressed. And again, like I'm impressed. They're working hard. I think diligent. I can't argue with that. Listen, when we started this, do you remember when we started this talking about this? We wanted to get rid of management, right? We wanted to get rid of management. That was like our first discussion. So we got rid of management. We did get rid of management. So I think that's pretty cool. Now getting to the finish line is where we need to get to, but I feel that we're in good shape. How it turns out, I can't guarantee, but I think we're in good shape, moving in the right direction.
Yeah. I mean, the fact that you had the receiver appointed still blows me away, to be honest with you.
Yeah. Well, was he a wide receiver or a tight end?
Receiver, wide receiver.
26-minute joke at 47 minutes.
I missed it. I was just so intrigued by what you were saying. I lost track of time.
I know. This is true, by the way. In California, they're coming out with a law that requires bi-directional charging for all EVs. I heard, however, that the trans-directional chargers are going to be suing. That's an original. That was an original me.
Did you make that up?
I did. The bi-directional is true. All right. You have anything else you want to say about GTII?
Well, there were some questions about what's going on with the Alpine case too.
Oh, yeah. Okay. So let me bring up to speed the Alpine. And you can blame the court. So last week, FINRA filed a letter. It's about the fifth letter these guys have filed.
That's all they know how to do.
They do. And all it does is it delays. Here it is. This is what they filed. So it's like a two-page letter with some case decided recently in the 8th Circuit. So it's not going to be, absolutely binding because there's no Supreme Court decision yet on this. But they're citing the case and says, look at it. So this is now, March was the end of oral argument. It had been briefed. So everybody had briefed it by that. So April, May, June, July, August, September. Now we're going into October, 7 months. Come on. That's absurd. That's that court, by the way. The Court of Appeal in the DC, I don't know what they're waiting for.
Yeah.
I have no idea. Why should it take that long? Really, man, that's really unacceptable. It's not like they don't have clerks helping them. It's not like they shouldn't be competent judges. That being 7 months after the case, that's shocking to me. So that pisses me off, by the way. I think that's completely unreasonable. The SEC on the other part, because I look at this every day. So I looked at Alpine today. I literally every day I go on the Pacer site. I pull up the Alpine case. I look to see if there's a decision. I see no decision. I then go to the SEC site. I look up enforcement decisions, whatever. I look up Alpine. I see nothing. Although I did see one thing that interested me. I looked at something that gave a history of Alpine with the SEC, and I've seen they've had 46 encounters with the SEC. Only 46 though. So, I heard, by the way, that the SEC warned them that on the 47th occasion, they were out. They're gone. They're gone. So they're almost there. But is that like ridiculous?
Like with 39,000 violations of the
why is it seriously why I mean, what do you think is the reason they have not kicked them out?
they don't care.
Well, I mean, it's got to be beyond that, because that's like the dirtiest of the dirty. I mean, you look at their record. Remember, like that sex that they wanted to hire the sex guy to be their their face
compliance person,
to be the face of the company. P. Diddley was going to be their number 2, right? So I got to use it that time, right? I find that really disturbing. In MMTLP, obviously, we got that issue about regulators not doing anything, but here the regulators have they've done like a half blank job. I don't know if this relates to the fact that Gensler is going to be out, because I think it's pretty clear now that after this election, in some fashion, maybe as a promotion or as a firing, one or the other, that Gensler is not going to be the head of the SEC. And maybe if that's the case, maybe he has like a standing, because it's not like that far off in time. Maybe they decided, I'm going to defer to the next guy who will make the enforcement decisions and whatever, and I won't impose that upon the person. That might be the way they're acting. But
I mean, that's a possibility. But
yeah, I'm giving them like really being sympathetic to them there. But it really is. It really pisses me off that they've given them so much discretion when there's no doubt. This is not like there's a question. Just look at their record. They know. And now, again, that's why I believe that the SEC knows about GTII. They have to know about GTII through Alpine. Just happens to be next door, adjacent, whatever. They would happen to tumble into it. So,
sure.
So that's Alpine. So when are they going to act? I don't know. And again, I've always taken the position. Maybe I'll let you go on here because I've been babbling for a long time.
No. I mean, look, these are the questions that are coming up. This is, I want to make sure that we're pinging these. So, I mean, look, we have talked about this 1,000 times. These are do nothing agencies. That's basically what their role is. The SEC's enforcement actions and penalties are a joke. I mean, go back to that space where Patrick Byrne was on when he talked about how, these companies that speak up against naked short selling and try to attempt to do something, they're targeted. Berta, Palicaris, we know that those guys are, been charged. Hamilton, they came after. Patrick Burns, they came after. I mean, it's part of the playbook.
Hoffman.
So that's the only good these agencies are for is, keeping these hedge funds and brokers and big banks, keeping them in their back pocket, or having the SEC in their back pocket is a weapon they can use when someone questions their game. That's the bottom line.
Well, we'll have to see how it plays out after the election, if there's any change, because you wonder. Again, there's so much money, right? So somebody who might be inclined one way, people are
Well, I think
influenced.
that the thing that I've been thinking about is DJT and Nunez. Nunez was very outspoken 6 months ago about naked short selling, and 6 months ago, DJT's stock was what, $25-$30 a
30.
share.
Mhm.
Now it just hit a low of $12, but yet you're
Right.
not hearing him say anything. I think that gives me, more confidence that they are doing something about it or formulating a plan if they do win the election to make some changes,
Well,
because
I was going to
the
thank you.
silence is deafening. Silence is deafening, given the fact that they're down 50% from where they were 6 months ago when he started speaking out.
Yeah, it'd be interesting because I don't know if about that, because I like Ham talks about Patrick Byrne. I think they dated once, by the way, Ham and Patrick Byrne. But I don't know if that's not true, by the way. I don't, or maybe true. I don't know if they lost, if it wouldn't be better, because I don't know if if it's a private company, right? And maybe if they can go, because they can't do anything really after the election. Really can't. It's or it's tricky, because then it's got to
Well,
be it's got to be kind of in a blind trust, whatever.
right.
I think
That goes back to some of the issues Trump had in his first term.
yeah, I think it's tricky. I think it's trickier to do. I think up through the election you could do something, but once the election happens, or maybe once an inauguration happens, I think it gets trickier. But I wonder if he doesn't win again. It's a private company, and there's no limitations at that point in time. And maybe you can go full bore. You litigate publicly, whatever. If it's been ripped off, then it's been ripped off. If that's the case, I don't know. It was down to 12. I think it went back to about 15. It's
Yeah.
it's.
I mean, it's bouncing back, but still,
Oh yeah.
So.
Yeah, and we don't really know why or what the basis is. Any other questions about GTII that you have?
Not that I have. Let me just make sure. I'm pretty certain I didn't. I made a mental note of all the ones that were coming up.
Yeah, so the bottom line with GTI is obviously I'll keep you apprised of significant events as I do. Sometimes I'll post on Twitter. I'll just like a quick little update. But again, we don't have control over timing. So I know that the receiver is acting quickly. And again, they don't get paid unless they bring in assets. So they're on the same team because we benefit if they benefit. And I'm sure they want to get paid as quickly as possible, and they want to get things straightened out as possible. I know that the Fortune CPA firm that was brought in to do a audit did do work. I don't think they completed it, but they made progress. I think they were waiting for some disclosures from the company that didn't come. I don't know who those disclosures were supposed to come from. Not the receiver. It was prior. I don't know who it came from. I don't know how much it was.
Okay. Yeah. Sorry.
Yeah.
There were some questions about the special dividend, and that's what I was looking for, guys. I knew there was one I missed.
Yeah,
so,
I think
so someone typed the question, and what's the question regarding the special dividend?
I'll answer it generically, kind of a general. So I'm sure they will deal with the special dividend to the extent they can. The issue will be it won't be their number one priority, because again, they got to get it trading and they got to get the audit done. Those two things, the audit being the most important thing, audit and whatever else needs to be done. Because I don't know what the audit might show. It might require other corrective action, but that's first. And then getting it trading. And then after that, you could do all the, things that need to be done. I happen to think if you get like the first part done, the rest is going to take care of itself. In other words, if it's turned around, then the dividend is an issue, but I don't think it's going to be as big an issue because other things will be reflective of the turnaround. If it's not turned around, it's kind of irrelevant. If that answers the question.
I couldn't find the question, but
could you speculate? Can you speculate if it answers the question?
Yeah, it sounds good. That sounds a great answer. Awesome.
Okay. Are there any other questions?
No, that was it.
Okay, so
I
if you
think
see any others as we go on, so you wanted to talk a little bit about the MMAT bankruptcy and bankruptcy in general,
I
with
just figured it.
your huge knowledge. I think you're a bankruptcy expert, aren't you?
No.
No.
I just thought it'd be a good idea because I'd gotten some questions. I popped on a
Right.
space a couple times this week because I was bored out of my mind laying on the sofa. And so had gotten a couple of questions about bankruptcy. So I'm sure many of you know Metamaterials filed for bankruptcy several weeks or months ago. And so the notifications are going out that they're in, I believe, Chapter 7 bankruptcy, which is liquidation. And so it's really the beginning stages of this. And so the notice that went out was a notice to the general public announcing that they've filed for Chapter 7 bankruptcy. And the reason they put that out is because under the bankruptcy laws, they're required to put out a notice to the public. Now, I don't know if they've updated the bankruptcy code, but it used to say something along the lines are, you had to run an ad in a major newspaper for 6 weeks prior to any procedure starting in the bankruptcy court. And so I don't know what the requirements are now, but it's something very similar where some general notice has to go out to the public that puts everybody on notice that the company is filed for a chapter 7 bankruptcy. And the reason they do that is because anyone that has any type of claim against the company has to get that claim submitted to the bankruptcy court, or they're forever barred from making the claim. And so the notice went out to, I believe, anyone that had their shares directly registered through the transfer agent for Metamaterials. Those people got the notice of bankruptcy filing. And so some questions came out on a space about, what happens to shares and that kind of stuff. And I didn't really get into it, but generally speaking, typically what happens when you go into a bankruptcy is you get dumped into a bucket. You're either a secured creditor and you're unsecured creditor, or you're an equity holder. And then those buckets have treatment based on the category they're in. So secured creditors typically get paid first. Unsecured creditors and equity holders are usually at the bottom of the category, and they're classified based on the type of claim they have and the amount of money that they're owed. But typically, equity holders are at the very bottom. So again, the process has just begun. There's going to be a lot more coming out as they work their way through Chapter 7 bankruptcy. Chapter 7 bankruptcy is liquidation. It's not reorganization. Chapter 11 is reorganization. So if they're in Chapter 7 bankruptcy, they're going to be selling whatever assets they have left to get money to pay the secured creditors. So,
yeah. I was going to say I would say this is a fair statement that if it's a Chapter 7 bankruptcy and you're an unsecured creditor, you're going to get nothing.
You're going to get nothing.
Yeah,
that's just the way. It's just the way it is. So, and my understanding was prior to them going into bankruptcy, they were selling assets off left and right to begin with. So there might not be many assets left.
Now, sometimes generally there's a trustee involved, private party who's operating to, in essence, on behalf of the court and the creditors, raise as much money as possible to pay as much debt as possible. And they get a fee. And if there's money left over, they get a piece of that too. So there might be a trustee. So what could you do? So, because that was kind of the question, right? And I think that's been a general question. What can you do? Well, we talked about Sorrento Therapeutics, right? That's one option, where Sorrento Therapeutics was the issue about whether you could maybe force a short to close. But the other alternative, if there's a trustee, you can contact the trustee. And if you think there's been shenanigans gone on, they sold the assets too cheaply, or there was some insider transaction or whatever, you could point that to the trustee and you can contact them. You obviously also, if you're a shareholder, although it's not legal advice, of course, you could, if you had an action, hire counsel and you could pursue an action. Now, that MMAT is also incorporated in Nevada, like GTII, for example. And in GTII, as been evident. If a case is of a sort where a receiver has been appointed in the past, then you can get that type of relief. That would include, if you're filing a lawsuit, there's ways that you might be able to seek relief against those who improperly sold it. But that means you have to get somebody to kind of lead the charge, pay the legal fees, etc. Not free. Reason why GTII worked is because we were able to do that. Otherwise, one person doing it probably just not feasible unless they're
Right.
like, JR could do it on his own. I think JR could do it. But other than JR, I think it'd be a tough hill to climb for everybody else. He's special.
Yeah, it is a tough hill to climb. I mean, and going into Chapter 7 is not. I mean, it's not good. But
yeah. So if I were a MMAT holder, I would find out who the trustee is, and you could find it from the bankruptcy. You could you call up the attorney representing there's an attorney on some document who's handling the bankruptcy. If you can't figure out who the trustee is, call them up. They'll tell you who the trustee is. If you want to find out what's going on about that particular debtor and whether there's actually going to be money available or what the status is, trustee will tell you. They're not going to, there's no reason not to. And there's also something usually called a 341A hearing, which is a meeting where the creditors come. It's usually like 2 minutes long. Usually what a 341A, so I've been to a few of these. Usually what happens is the trustee who's running the hearing, there's no judge. There's a bunch of people in the room and they all have filed bankruptcy. And the trustee has to basically analyze the petition to see if they can squeeze some money out. So what happens is there's literally like 50 debtors in one hearing. So the trustee has 2 hours to go through 50 different people. Plus they have to get off. They come up to a table, they sit down, there might be language issues. So that's all within that 2 hours. So you can imagine how thorough their evaluation is. Usually what they do, what they see them do is they'll have a pack of documents. They'll open up to like page 33 and they'll ask a question about page 33. I'm using that as an example. But that's what the trustee does in part, is to raise money. So if you think there's been shenanigans going on and you want to satisfy yourself, trustee is somebody you might want to speak to, because they might want to, because the trustee, again, if you told them or were able to convince them there was money to be had, they would probably be participating in that to some degree. So they would have a self-interest and they might be interested. They also may not be, by the way. It's possible. They might think it's dead or too difficult, etc. But that's who I would call if I wanted to figure it out. I wouldn't call the bankruptcy counsel because I don't know if that bankruptcy counsel would give me an honest opinion, because they're representing the debtor,
right.
In that case. But the trustee, maybe somebody else. So anything else about bankruptcy per se that you wanted?
No, I just wanted to kind of give kind of let people know what was going on. That's all.
Okay. I know there's still stuff going on with MMTLP and efforts in court, I think. There's still, I guess everybody is still fighting that arbitration issue. Seems to be, not shockingly, it's a common issue. And obviously it's not sufficient.
Well, Mark got a decision today that FINRA is not.
I didn't see.
Yeah.
I wasn't aware of that. What was the decision?
That FINRA isn't going to be considered a nominal defendant. So, which I didn't get to read the decision.
What does that mean?
Well, you know what? To be honest with you, I don't know what he was trying to do with it. So, but
was that good for him or bad for him?
I think it's indifferent, to be honest with you.
Okay.
I'm not sure what purpose it served, because the real hurdle is disqualifying them as partial or impartial.
Being an arbiter, or controlling the arbitration.
Right.
Yeah,
right.
because in GTII, just to kind of put it in to match it. So there's 4 individual defendants, and this is Nevada, 4 individual defendants, I think, and GTII is a nominal defendant, but they're not a defendant. They're because they're basically the derivative plaintiff.
Right.
But you call it because they have an interest in the proceedings. That's kind of why they're there.
Right. So really, it's indifferent. The fact that they ruled they weren't going to be considered a nominal defendant. So
Yeah, I think that yeah,
had real bearing.
the big issue that still remains with regard to any kind of action against the broker is that silly arbitration provision and getting courts to, unwind that.
Right.
Yeah. And again,
So and then,
I would believe it would be less because I think it was directly involved in MMTLP. Any arbitration involving MMTLP was impacted by the fact that FINRA had immunity, and it was not touchable. You couldn't get
Correct.
documents. You couldn't get anything.
and then Scott filed a motion.
Is this new?
A motion in response to the someone's motion to dismiss. He filed that today, I guess. So,
Was it a response to the motion to dismiss or a separate motion?
no, it was a response to let me rephrase that. I briefly read it because it was right at the end of the day. I believe it was a response to a motion to dismiss. I could be mistaken.
Okay.
But he posted it. It was out there. So I just glanced over it and was kind of reading the first and last sentence.
Yeah, in my case, it'll be interesting. So I have a motion to dismiss and an anti-slap motion, which is a motion based upon the fact if someone tries to take away your First Amendment rights, that's what's protected. So there's a procedure for doing that. But mine aren't going to be heard till probably for another month or more. So I don't know. It's quite some time off. The ones in Nevada will be heard sooner. Scott's, I don't know if hopefully he'll get an oral argument, but that's a question also because the judge doesn't have to give him.
Oh, they're still bouncing motions around. I don't know if everyone's actually filed their motion to dismiss. I don't know where the timing of everything is.
The broker wouldn't file. Well, he could file a motion to dismiss or a motion to compel arbitration.
Well, it's the motion to compel. Yeah, let me rephrase that. Yes, the motion to compel arbitration. I don't know if that's even been filed yet. I know FINRA and a couple of, he's got a bunch of defendants that he's listed too.
Right.
So, I think they're all still kind of in the time period to respond to things. So I don't think there's going to be a ruling anytime soon.
Yeah. And I would guess my guess, and I don't know this for a fact, but based upon the fact he seems to be putting in a lot of work, my guess is if they deny, in other words, if they force him to arbitration, my guess is he'll appeal that.
Yeah, sure.
Yeah. But that's the problem that we all face is the limitation on getting evidence. If we could get obviously to those who don't know MMTLP, that's a stock. How long has it been? 2 years? Yeah, almost 2 years exactly.
Yeah.
December of 2022, stopped trading U3 halt, never settled. Everybody's stuck. And the FINRA and the SEC have been certainly lack transparency. I'm just being given the benefit of the doubt.
And that's one of the reasons why I still make the argument that a claim under the APA is still a better approach because it's not the evidence you need and logic that went into the decision.
Yeah, that APA.
You gotta poke holes in.
Yeah, I think you should do it.
Thinking about it.
Yeah, I know.
Yeah,
I know. I was going to say, unfortunately, yeah. Everybody out there, that's what when JR is stumped, when he doesn't have an answer, what he says is APA, the Administrative Procedure Act. That's the answer to every question. Why the Eagles lost on Sunday? Because of the APA, obviously.
You're just jealous because you didn't think of it first. You took the standard approach. You didn't put any legal creativity into things. You didn't think outside of the box.
What is that? Let's see what this question I saw.
Trustee claims 3% of the total recovered given the West Christian lawsuit assets.
I'm not sure
idea. I don't even think that is a question.
Yeah, maybe it's a statement of fact.
I think we hit every question up that I could see. I'm not seeing any more questions or any more comments come in, so I think everybody left.
Okay, well that's fair enough. They could have split. I would have left too by now, if I could. JR has been just blabbing about the APA. What can you do? What can you do?
Comfortable. That's my problem.
All right. And anyway, by the way, I appreciate everybody being here. We appreciate the questions. We appreciate that everybody kind of thoughtful.
Blue Five's still here. Thanks, Blue Five. You're a
Yes,
trooper.
at least one person is still here. It says actually this,
I
honestly,
would laugh.
I know. Actually, on the if I could see the number, actually it's 500. So it's not. It's I know
500 people are still here
Yeah,
listening
500.
to this shit.
I know 505 actually. Yeah, I know it's amazing. Whatever. But I appreciate it, by the way, and I appreciate when people are asking like difficult questions and pushing and thinking. It's helpful. It is helpful. It kind of because like everything else in school. I remember you'd sit in a room and everybody afraid to ask a question, and then the person would ask a question, and it was the same question everybody else didn't know.
Well,
but
sure, it's always that way. I was never afraid to ask questions.
Well, you should have been. You probably should have been. It would have been helpful, I think.
I probably would have shut my mouth more.
Yeah. So, is there anything else on the legal side that we should talk about?
On the legal side?
Yeah.
You know what? I don't. Not off the top of my head. I mean,
are you going to watch the debate tomorrow night?
No, I don't watch those things. I get my blood pressure.
That one I'm not going to watch either. That one. I don't know if I'd watch a second debate on the president, the vice president. No. Have you ever watched? Have you ever watched a vice president? I don't think I've ever watched a vice presidential debate.
The last presidential debate I watched, you're going to laugh when I say this, was Bush versus Kerry back in 2004.
Kerry was from that horror movie, right?
Yeah. Kerry actually destroyed him that night. Bush he looked like a deer in headlights. It was that very first debate.
That's why Kerry became the 39th president of the United States. Yeah.
Look, I didn't say it. You know what I mean? I just remember it. I watched it over at a friend's house, but that was the last one I watched was that one.
I was in Boston once, and maybe Beacon Hill, some area that was nice in Boston, and that's where he lives. But it's like literally his house is on the street. See, if you're just walking down the street, you want to go knock on his door. Yeah. It was pretty open. So what?
Leader Landscape said it was 500 bots that were watching.
It might be. That's true.
Maybe GTII's counsel too, or Reichman's counsel.
That's true. No more probably because they're out.
Oh yeah, they're out.
Yeah, they're not. They gave up. Anything else?
No.
Yeah. All right. For everybody out there, I really appreciate you. Really. Yep. Thank you for watching. Thanks for all the questions. Like I said, tomorrow I'm going to do starting the 30-minute daily
news
raw
segment.
Daily raw news, RAH, raw news. So join me if you want or not. All three of you out there, if you want to join, if you have a question about the news, by the way, I'm happy to put it in there. And obviously, we'll keep you apprised of everything else that goes on. What were we going to say?
I was going to say maybe I'll make a guest appearance on the news show.
Oh, yeah. JR has a standing. He can be my standing guest whenever he chooses, whenever he can come along.
I'm your co-anchor.
Sometimes, I kind of co-anchor. Sometimes it's a little difficult because of the time. We're on 3 hours apart. So for me, like 12:30, I can do.
Oh, John, that's John. Oh, John, I didn't know that was you. I'm sorry.
Oh, okay. Leader Landscape.
Yeah, it's John Bowen.
I like that name. Leader
Landscape.
Landscape.
And I have a love-hate relationship. He's a good guy.
Because you love him and he hates you.
Yeah.
Is that it? No.
Nah, he's a good guy.
He is. Yeah. He's always thinking about things, so it's cool.
Exactly.
Yeah.
Exactly.
Anyway, I don't think I have anything else to add, so I'm going to let you go. So if you have comments, questions after this is posted, and we can answer them, then great. If we hear anything in the meantime, we will let you know. And again, starting tomorrow, if you want to hear some raw news, feel free to jump in.
I might have to clear my schedule at 3:00.
3:30. 3:30. And again, appreciate everybody who watched, and look forward to seeing you again soon. Take care. Have a great night. Be well. Be safe. Say goodbye. My hand